Hey, welcome everybody. Thank you for joining us today. I have with me Kevin Fasic, who is an attorney with the ADA. He is in Wilmington, Delaware, close by where I'm at, and he works with a firm called Offit Kurman. And maybe some of you joined us the first go around when we did a webinar on the ADA and questions to ask. But both Kevin and myself, we both had technical difficulties. So we're just going to have a conversation this go around. We actually have a list of questions that our members asked. What we wanted to do today is talk a little bit about what the ADA is, it's the American Disabilities Act, how it pertains specifically to vision loss, choroideremia per se, questions that our members have asked. And, this is something, Kevin, that we have in our support groups. It's talked about in our men's conversation groups. It's actually talked in parents group. And, we're going to have it be a session at our conference, which unfortunately did not happen in 2020 due to COVID, which we are going to have. So maybe you can come up to Rochester when we have it next year. It's in beautiful Rochester. But it certainly is something that's really important to our members. And there's some key questions that the gang that joined us last time had. And so I thought we would just go ahead and have a conversation. I want to make sure too that I always want to thank our sponsors, which would be Santen, Biogen, and Spark Therapeutics. They give us funding, grant money to hold these, and we're super grateful to them. So can you show us your mug? Let's start off with something fun.
Okay, there's a story to the mug. My former legal assistant, who had a wonderful sense of humor, bought me this mug for Christmas. It says opposing counsel's tears.
There you go.
And this is the same assistant who last Christmas bought me a dozen of these. They're little army ducks, okay, because I was in the service many years ago. And I now have various little army ducks decorating my office in random spots. Yeah, it's a very eclectic office. It is the only law office you will ever see that has a camel saddle in it. And when my firm brought us on board, they said, tell us 3 fun facts about yourself. And I talked about a couple of things. And I said, I'm the only lawyer you will ever meet who has a camel saddle in his office. And it got the intended result. I had a number of people who said, you have a what, where? And it is actually, now I'm sure it is a tchotchke that my grandmother purchased 2 of these on a trip through the Middle East in the 1950s or 60s and had them in her home. And when she passed away, I was still very young. I was about 10 years old, 11 years old. And I loved these things. I thought they were the coolest thing in the world. So I claimed them, and they were in my room as a child. And I had one in my room at the fraternity house in college, and it actually survived. And years ago, when my parents were moving out of their house, I found them up in the attic, and I brought, well, one of them was demolished. The other one was still in decent shape. Brought it home, said to my lovely bride, hey, look, this is the camel saddle that my grandmother, blah, 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 blah. It's going to look lovely in your office. Well, but honey, no, it's going to look lovely in your office. So, oh, okay, I get it. So it's in my office, and it's a very eclectic spot, and it's kind of, given the amount of time I spend here, it's home.
There you go.
So
I'm with her. I think I'm with her. Hey, I'm gonna open it up with before we get into the questions. Before I hit the record button, you and I were having a conversation about how the ADA and people's jobs and employers and situations are all different. So maybe
Yeah,
what you can do, if you wouldn't mind, is maybe just give us a ever so brief what is the ADA, and
sure.
how it can be work on our behalf, and talk to a little bit more about the point you were discussing with me.
Absolutely. So the Americans with Disabilities Act was passed approximately 30 years ago, 1991, 92 time frame. I want to say 90, no, 90, 91, somewhere in there. The express goal is similar to laws that prohibit discrimination and harassment and retaliation on the basis of race and gender and age and things of that nature. The ADA is intended to prevent discrimination, not just in employment, but in a lot of other areas. More broadly, things like housing, things like public accommodation. My focus in my practice is on employment. But the intent was to protect people who have disabilities, but still have the ability to perform the essential functions of a job, either with or without some sort of reasonable accommodation. And the Congress recognized that there's a whole contingent of people out there who, while they may have some form of disability, they still have the ability to perform a job. They may just need a minor accommodation, or maybe a somewhat more than minor accommodation. That would allow them to become productive members of society. And it, over the years, the statute was amended pretty significantly back in 2008 to actually broaden the protections. And it's a very tricky statute that, it has implications. It ties in quite often with things like workers' compensation, Family and Medical Leave Act. There's a whole alphabet soup of different laws out there. And I think the trickiest thing, I spend a great deal of my time representing employers and counseling them on compliance with the ADA. Now, I've also done plaintiff side cases over the years. In fact, I think I may have mentioned this during the presentation. I had a case a couple of years ago that was an ADA case. A colleague of mine tried the case in federal court here in Wilmington. The employer appealed it up to the Third Circuit Court of Appeals and then to the United States Supreme Court. It's one of two cases in my career that I've had that have gone up to the US Supreme Court, which for us is kind of like going to the Super Bowl. And I'm 1-1 at the US Supreme Court. We had one case that they dismissed unfavorably for us. And this particular case, the ADA case, they found in our favor. What gets very difficult is that, no two situations, no two employers, no two scenarios are exactly the same, which is one of the things that makes the ADA, especially difficult, especially tricky, particularly when you have an employer that says, okay, this is the law, we're going to comply with it. How do we do that? What's the formula, Kevin? What boxes do we have to check? And it's very difficult to say that with specificity because every individual employee and their needs, whether they're actual or perceived needs, are going to be different. You and I may suffer from the same disability or the same condition or something of that nature, and we may require accommodations that are similar, but we may work for vastly different employers. You may work for a very small mom and pop shop. I may work for a global corporation. You know, the resources there are vastly different. Does that necessarily mean that I'm going to get whatever I ask for and you're going to be stuck? Not necessarily. I've had small employers, and keep in mind that under federal law, ADA covers employers with 15, that's 1-5, or more employees. Under state law in Delaware, it is 4 or more employees. Having a small employer does not necessarily mean that an employee is not going to be accommodated. I've had several smaller employers who, you know, really treat employees like family. And again, small employers who have really gone out of their way to assist and accommodate an employee just simply because they're good people and they want to do the right thing. I've also seen very large employers who get very formalistic and very, well, if we do this for this person, we're going to have to do it for this person and everyone else. And we don't want to, you know, set absolutes and standards, and we'll do this, but we're not going to take it to the next level. I've had all kinds of different types of scenarios there. And, you know, employers who think, well, you know, they're just going to have to deal with it. You know, that we don't have to do anything for them. So there's really a whole range of scenarios and situations that you can come to with the ADA.
All right, here's the first question that a lot of people have is, when it comes time to apply for a job or a new job, should you disclose prior to hire that you have that you're legally blind, or that you have an eye condition that may limit your visual capacity?
Well, I think that there are a couple of schools of thought on this. In order for the employer to provide any kind of accommodation, they have to know. I mean, they have to know what it is they're accommodating. And, you know, oftentimes a disability will be something obvious. Someone shows up in a wheelchair, for example. With this situation, you know, it's a little bit trickier because it's not something that I think a lot of folks who are doing, you know, hiring are necessarily going to pick up on in the pre-hire or offer of hire stage. So I do think you are running a bit of a risk if you tell I don't think it necessarily has to be the first thing you say to the recruiter or the hiring person right out of the gate. Oh, by the way, before you look at any of my qualifications, I have this condition and you should know about it. I think that as you're discussing the qualifications, you can kind of read the room, so to speak. If the recruiter or the hiring person it seems like they're just going through the motions, they may not be all that interested in hiring you anyway. It may just be you're the 10th person they've interviewed that day and they're just, you know, trying to get through it. But if you have a scenario where your qualifications, you know, you are qualified to do this job, I think what you what you want to do is have a discussion with the employer about, your qualifications, your education, your training, what makes you a good candidate for the position. And I think that at some point you can say to the employer, look, there is a situation that you should be aware of. I do have limited vision or legally blind, or, I have this condition and it affects my vision in a variety of ways. And if hired, it's possible that I may need some kind of accommodation to assist me in performing the job. Now, any recruiter or hiring person, frankly, who is worth their salt, is already going to know and be able to say at some point to the applicant, here is the job, here's what the job entails. Can you describe how you would perform this job, either with or without a reasonable accommodation? They can come out and say, do you have a disability? Do you have any kind of problem that would prevent you from doing this job? That's sort of contrary to the whole idea of the ADA. But an employer can, it certainly is very legitimate for an employer to say, these are the conditions of the job, the essential functions of the job. Can you describe how you would perform them with or without a reasonable accommodation? So I absolutely think that it is an important topic to discuss. Are you taking a risk? Absolutely. Because all of a sudden you may no longer be that great candidate for the job. And, it is a risk, but I think it's also important that by not disclosing it, but any kind of a condition that would affect the ability to do the job, you're not being 100% honest with the employer. And, I've had many situations where employers have called me up and said, well, they didn't tell me about this until we had already hired them. And what you've really done there is you've created a contentious relationship with that employer from the get-go that did not have to be there. Okay. If the condition is discussed upfront in an honest and forthright way, and someone says, I can do all of this, but I'm going to need this type of accommodation. And it doesn't hurt to, to go in armed with some knowledge. There's a software that is off the shelf that, can be acquired that would allow me, to see things larger on my screen, to be able to do this and such. It's very simple. It's very inexpensive. I don't know if it's expensive or not, but if there's a software out there that is commercially available, I would assume that it is something that could be acquired for a reasonable cost. And I think my opinion is it's better to be forthright, upfront, and sort of put the cards on the table. Because quite frankly, if the recruiter responds in a very negative fashion, that may key for the applicant that this is really not a place that I necessarily want to be working.
It's true.
So,
do you think you would wait until, Kevin, would you wait maybe until an offer comes? Maybe not the initial, because most interviews you have one, usually two, or you have that dialogue. Maybe it's that I would think maybe you want an even playing field, right? Until you get to that point
sure.
where you're maybe on a short list or something.
That if you have a scenario like that, I would absolutely agree. If it's a situation where the employer says, look, we're going to do a first round of interviews, narrow the field, do a second round, and then we're going to have a third and final interview with the top 2 or 3 candidates. Is it necessarily going to hurt to wait until later in the process? No, not necessarily. Spend the first interview talking about why you're the best person for the job and why you have the most experience and training, and you're the best thing in the world since sliced bread, and you really deserve that job. And then to have a discussion when they start to get down to brass tacks and say, okay, you'd be working out of this building, in this town or this location or whatever, then maybe that's when you want to get into the, broach the subject.
Mm-hmm. You spoke about accommodations, and that's another question as I look down here. If a CHMer needs reasonable accommodations, can you give us some examples? We talked about that a little bit already. We're on number 2, lighting software that a blind or low vision person may ask for.
Well, it's a little difficult for me to answer that question, only because I have limited experience with people who I'm not going to attempt to pronounce the condition because I will butcher it horribly.
CHM. You can just say CHM.
CHM, okay. It's not something that I necessarily could say, and I frankly would be very presumptuous to say, well, you need this and this and this. I think it really comes down to what the nature of the job is, and what is it that particular individual needs in order to make it easier for them to do their job. I have worked with an individual who, in a different nonprofit organization, addressing vision issues, and this particular individual was legally blind. They could not drive a car, but they had an office. Their lighting in their office, these wonderful, fluorescent, horrible things that we have, they were turned off. The individual had, soft lighting in a couple of different places in the room. They had a computer monitor. It was the most ginormous computer monitor I think I'd ever seen. It was, I don't even think my TV at home is this big. And they clearly had some sort of software. We were going through an agreement, and he was able to bring this agreement up on the screen and expand it such that he, even with his limited vision, he was able to, read and understand everything that was on the page. So I think it as I said, it really depends on the individual. Light may very well be a factor if having an office that has softer lighting or indirect lighting, that might be something that would be beneficial. I think if you're working with any kind of computer operation, which many of us do these days, certainly if there is a software that is designed to assist, a larger monitor, certainly. I noticed.
Hey, Kevin, I'm sorry to interrupt. Sure. Is that something that, would you recommend that would be something that the employee would have to provide for ourselves because we need it? Or is that something that you could ask the employer if they would be, because that's really expensive?
Sure.
Are they mandated?
Well, with respect to reasonable accommodation, when an employer is faced with a situation where they have an individual who has a disability, the term of art for the discussion is what's called the interactive process. And the intent of that process is for the employee anyone who is advocating on behalf of that employee, a healthcare provider, a physician, doctor, what have you, and the employer, to have a frank discussion about what reasonable accommodations will assist the employee to be able to perform the functions of their job. You know, things, and the standard for what is a reasonable accommodation, you know, there's no dollar threshold, but the employer does have a, I hate to use the word defense, but that's essentially what it is. If the accommodation would pose an undue hardship on the employer, then it is not something that the employer has to provide. For example, if you had a small mom and pop shop that, you know, only did, you know, a few $100,000 worth of business in any given year, and you said, well, you have to buy this $250,000, you know, whiz-bang computer system to allow me to sit here and do your books for you, or whatever it is your function is going to be, that employer could very well say, yeah, I can't afford that. Even a larger employer might say, hey, you know, that's just way too expensive. With a reasonable accommodation, the accommodation that the employee requests does not necessarily have to be the accommodation the employer provides, so long as the accommodation would allow the person to perform their job, you know, and perform the essential functions of their job. That is all the employer has to do. You know, an employee might say, I need a, you know, a gold-plated mouse because the gold, you know, reacts with me better and I work better when I'm touching gold. Well, yeah, you know, that's not going to happen. Here's a nice black plastic one you can, you know, adjust to. So it, you know, it, again, I hate to be a broken record with it, but it really depends on the circumstance and the individual. You know, does the employee have to buy it themselves? No, that's not an expense that the employee has to bear. So an employer were to say, well, we'll buy you the big computer screen, but you're going to have to pay that off, you know, through a payroll deduction. Absolutely not. That is the employer's responsibility, not the employee's. Now, if an employee has a particular tool or device that, you know, they can bring with them, this is always, you know, individuals who have back problems and they want to bring their special pillow, and it's the pillow that works for them all day, every day, and they want to bring that in. Sure, you know, that's not that's not what we're saying here, but purchasing the software, the license for the software, the installation, what have you, larger monitor, that's really something the employer should absorb that cost. Again, subject to the undue hardship standard.
If would you recommend then, if that was starting to happen, somebody's employed, we're starting to see issues with our vision, we notice that we do need some accommodations to our work site, our software, what have you, would you recommend that we start with, if we have somebody in the HR office, we should call them first, we talk to our direct supervisor? What's the chain of command or communication do you think is most effective to protect our rights?
Well, I think that certainly having a discussion with one supervisor, if the supervisor is effective and the individual employee is starting to have some difficulty with their computer screen, being able to really see things. And I guess the one question I would have is, At this point in time, is the employer aware of the condition of the CHM, or the fact that the employee has a vision disability in some way? I think it's always good to keep the supervisor in the loop, so to speak, and to be able to say, look, I think I need to have a discussion with HR. I'm starting to have some difficulty. What I have right now has been working, but because this is a degenerative disease, I'm starting to experience some problems, and I think we may need to move to, the next level here. And really, again, broken record, it depends on the circumstance. If your supervisor is someone that you have a good relationship with, they're a good supervisor, they're fair, he or she is probably going to be smart enough to say, well, let's get you an appointment with HR, tomorrow morning, and let's figure out, is there anything we can do right now that would assist, that would, address the circumstance? Or you might have a supervisor who is a not quite so enlightened, decent human being that, what do you mean you got to get HR involved? It really just depends on that situation. If you have the latter, maybe you just want to go to HR on your own and, not involve the supervisor. I don't like that, because one thing supervisory and managerial people do not like is being blindsided by HR. And that's, probably a very bad and, term to use, but when that supervisor has HR calling them and saying, we want to talk about Kevin, he's come to us. Oh boy, the supervisor, what happened? What's going on? I don't know anything about this. This is coming to me out of the blue. The supervisor is going to feel like, well, why didn't you just come and talk to me? Okay. I prefer the approach where the employee goes to the supervisor and says, look, you're aware of my circumstance and my condition, starting to experience some difficulty here. I'm not sure that the existing footprint of what we have is really working. And I think I need to have a discussion with HR. The supervisor might be able to make some suggestions. Like I said, well, what if we did this? Or what if we moved you to a cubicle further away from the windows where you're not getting as much, direct light or, things of that nature? Maybe we can do some things before we have to escalate it to HR. And those solutions may be just the thing, to address the situation. But I think it's always good to get the supervisor involved as early in the discussion as possible.
That's good. That's good advice. And then document, right? Document any.
Oh, yeah, absolutely. If you have a discussion with your supervisor, it never hurts after they have moved on to shoot a quick email and say, hey, Bill, really appreciate you taking the time to talk to me today about, some additional accommodations that may become necessary. I really appreciate your, understanding approach. And, I look forward to having a further discussion with you. And then, you send that email, you print it out, you take it home, you put it in a folder at home so that you have what is then called, in my world, evidence. You have the evidence that you had that discussion on that day. Because when you get to my level, well, we had that conversation. No, we didn't. I never had a discussion with Kevin about that particular issue. Really, Mr. Smith? Well, here's the email that he sent you. Oh, well, I guess maybe I did. Boom. You've just totally undercut that person's credibility. Those are the gotcha moments. They don't happen in a courtroom. They happen in depositions. And, any attorney worth their salt will have already said, hey, they have an email here that had this conversation. Oh boy, I guess I, better try to remember. So it never hurts to have that.
We're going to move on. That's good. Thank you. We're going to move on to another question here as I read it. Now, number 5, actually. On the
Okay.
question of equity in employee benefits, does the employee with the disability have the right to receive all the similar benefits of somebody in the same position? I think what someone was giving the example, they were on chat, when we were having our previous webinar. And so if somebody had a parking allowance, to it's $200 a month and you were giving that to you, and you know what, I don't drive, so can I have that $200 to use for Uber? Can that be discussed to have that same benefit to use in other ways?
Well, I think that it is possible a scenario like that. If the employer provides a parking stipend to employees that would allow them to park in the building or a local, parking facility, and they do this consistently across the board with all employees. And if they don't provide a parking allowance, they provide some sort of they will purchase your bus fare, if you have someone who takes public transportation, or a, train fare if you live in the suburbs and you commute into the city for work, to allow you to take the train or something of that nature. If it's a benefit that is being provided to employees generally, then yeah, I don't think that the employer could legitimately say, well, we don't have to provide that to you because you don't drive. I think that the employer could get themselves in trouble in that situation, but it is, there may be a particular reason why certain employees get a particular benefit and some employees don't. You may have a particular benefit that is only available to higher level employees. And if the individual, even without the disability, they would not qualify for that benefit, the employer may, in that circumstance, have a legitimate reason for saying, no, I mean, with or without the disability, Kevin is not going to get that benefit. Kevin is not entitled to that benefit because he doesn't fit the criteria for it.
Sure.
Then they don't have to provide that. But if you have a circumstance where, but for the the issue with your vision, you would qualify for that benefit, then I think in that circumstance, the employer would have to find a way to provide that, because it's essentially compensation. I pay so much a month to, park in my parking garage here. And, that's a burden that every employee has. You have to find a way to work. And, if my employer paid that for me, but they refused to pay it for another employee who was similarly situated, but had some kind of a disability or something of that nature, I think the employer would very much be at risk for an ADA violation there.
Mm-hmm.
Certainly possible.
You just spoke of ADA, and it kind of goes to the next question in 6. Is there anything, generally speaking, that the ADA covers for people with low vision? We have some folks who are carriers like myself, not really experiencing, I have glare issues, I have other things, but We have people who basically it's our periphery that is affected first, and night blindness. We don't see well at night. And then it gradually goes into the central vision, and then pockets within our central vision start giving out. It's very slow. Person to person, even in the same family, it can be different. But in terms of general guidelines for blindness or being legally blind, are there certain things that we as a group or as a legally blind person need to be aware of?
Well, looking at the question, in order to be covered by the ADA, for employment purposes, the individual has to be what's called a qualified individual with a disability. What that means is the individual is qualified to perform the functions of the job and can perform all the essential functions of the job, either with or without a reasonable accommodation. So it is, someone who is just been diagnosed with CHM. I think arguably once you have a diagnosis of some sort of a condition, you could be considered disabled from that point. Now, initially, if it is a degenerative disease, the accommodation or accommodations that you need may not be very significant initially.
Right.
It may be, well, for right now, I just, I need different lighting in my office.
Mhm.
Okay. And, if you have a particular type of lamp or a light that you use at home, or light bulb or something like that, and you want to bring that in and shut off the bright lights and have softer lighting in your office, certainly nothing wrong with that. That can always be the case if you're working in a cubicle farm with 100 of your nearest and dearest friends. That may be a little more difficult to provide that for you, because everyone is sitting in a big room with these giant lights above you. Maybe they can find a space in that room that is not quite as affected by the lighting conditions. Maybe there's some kind of screening or something that could be installed that would limit the amount of light that you're exposed to while you're performing your job. Maybe there is, I've seen folks who had screens over their computer monitors that limited the brightness of the light coming off the screen. I don't know. I think that's actually something in many cases that can actually be adjusted by adjusting the screen settings.
Mhm.
And you no longer need that screen over it. You can adjust those settings on the screen itself. I know for a fact that, setting the size of the text that you're reading on the screen, that is something that is pretty much universal now. When I started using computers back in the dark ages, where it was a totally different kind of system, we didn't have those. We had monochrome screens, and technology has certainly come a long way with it.
Right.
But anything that the employee can do on their own that would make things a little different or a little bit easier to perform the job, there's certainly no reason why the employee can't do that.
Good.
Um,
Okay.
where it gets a little tricky is, when you have coworkers that say, well, why does Kevin have that really cool screen in their cubicle? I don't have a big screen like that. Yeah, well, you also don't suffer from, vision problems.
Mhm.
So be happy that you don't have to have that big screen. That's where a lot of times people get, people who are ignorant of the circumstance of, well, Kevin got a great big monitor in his cubicle and I don't get one, and that's not fair. Well, yeah, it's not fair that, Kevin has, vision issues that require him to have that monitor. Um, that's where it can get a little sticky in the office sometimes.
Right. And that's where we have to be able to be transparent and have those conversations, or even telling one or two people. And then, of course, word goes out. You know,
Sure.
I have a great colleague who serves on the board of directors, and he was, as I understand, he was in his office oftentimes on his computer on one of those big monitors, and people would be going by glass walls waving to him, and he didn't see them. And pretty soon they started having an opinion, like, okay, what's up with him? He's not, being a jerk or what have you. So finally his boss comes in and says, okay, we got to have a discussion because there's some stuff going on in the office and the dynamics, and people are going by, they're waving, they're saying, hey, you're not responding. And he's like, man, I didn't even see him. And it was just simply one
Right.
of those things, communication.
Oh,
I
sure.
don't want to take up too much of your time, but there is one more question I think that's really important. Number 7, and then we're going to share some resources. And we have had some people in our community that have had this happen. If you feel like you've been passed over or let go, fired because of your visual disability, what are our next steps? I know we're going to play the card, right? That every employer is different, but can you just give us a couple steps like A, B, C, or 1, 2, 3?
Sure. Well, first thing I'm going to do, if I can do this, is share. So if an individual feels that they have been discriminated against or harassed or retaliated against because they tried to assert their rights under the ADA, there are a couple of things that a couple of steps they can take. Certainly, they want to let HR be made aware of this and say, look, I went to my supervisor, that I have this condition. I asked to discuss reasonable accommodation, and my supervisor told me to sit down, shut up, and do my job. You don't need any accommodations. You just need to work harder. And look, I'm letting HR know that, I feel that this is being discriminatory. I do have a condition here that requires me to have certain accommodations in order to be able to perform my job. Or, I've told my supervisor, look, I need this, or I need to talk with someone about reasonable accommodation. And instead, the supervisor gives the person a bad review. They're not performing fast enough. They're not performing up to speed. They're making mistakes. These are mistakes that would not be made if I had this accommodation and I could actually see what the hell I'm doing. I think going to HR is always the best next step. Certainly, this is when you want to start building the file. When you meet with HR, you want to go home and you want to record this somehow. Whether it's on your computer, whether it's in a notebook, whatever you prefer to do. On Tuesday, May 11, I met with Beth in Human Resources, and this is what we discussed. You want to have that record of the events that occurred so that if it gets to the point of needing to go through an investigation or ultimately go through a trial, you want to be able to have that record that you can show these are the things that happened and when they happened and what I was told. An HR person, a supervisor, they're not going to remember what they told you 6 months, down the road. But if they said something particularly harmful or hurtful or what have you, you want to make sure you have some kind of record of that, because most people are not going to put that in an email. If you're, you've got someone who is so bad at their job that they do put that in an email, you want to make sure you keep a copy of that email. But 9 times out of 10, it's going to be a verbal discussion and you want to keep a record of it. HR is always the good first step. Give the employer the opportunity to do the right thing and correct the situation. If they fail to do that or they refuse, because keep in mind, human resources is there to protect the employer. They are there to try to ensure that the employer is not going to get sued by doing something stupid. They don't always accomplish that. If you feel that you are in a situation where the employer simply is not, they're allowing discrimination or harassment, or, you've gone to them about accommodations and in response you get a lousy annual review or something of that nature, that, well, you're not getting a bonus this year because you got a crappy review. Well, wait a second, you're only doing this in retaliation for me trying to assert my right, my rights under the ADA. There are a couple of different avenues that you can take, and you should have these on the screen. And Beth, I think if I didn't provide a PDF of the materials before, please remind me and I'll get you a copy set of those.
And let me ask real quickly, on the very bottom, it says labor.delaware.gov. Is that similar? We can put any state, we can do labor.texas.gov?
No, that is the Delaware Department of Labor. And the reason I have that in there, the state, usually every state and some larger municipalities will have, could be called human relations department. Usually it's something related to anti-discrimination. In Delaware, the State Department of Labor has within it the Office of Anti-Discrimination. That is the agency in Delaware that investigates and attempts to correct situations of alleged discrimination, harassment, or retaliation. Labor.delaware.gov is the the website for Delaware, and I've got the phone number there. What I would recommend, though, is if you're in, Michigan, I would just do a Google search, state government, anti-discrimination, anti-harassment. Discrimination is usually the good buzzword to use. Most offices have that somewhere in their title. That is what I would recommend. If you're in a different state, just do a Google search. I'm sure it'll be one of the top, results that you get. Or on the federal side, and again, I've given information for the Philadelphia region, the www.eeoc.gov, that is for the EEOC nationwide. Okay, so that particular, and in fact, now that I think about it, if you went to that website and you were looking to get information on your local agency, I would imagine there's probably somewhere in their Byzantine website, there is probably a listing of local, they're what are called Fair Employment Practices Agencies, or FEPAs. And I'm sure that on the EEOC website, they have a directory of where you would go if you're in Michigan or Massachusetts or Kentucky or wherever you happen to be. But there's an 800 number, there's email, that's a local fax number, a TTY number, ASL video phone. And one of the the good things about, some people will say, well, should I go to the Department of Labor or should I go to the EOC? It really doesn't matter, okay? If you go to, and each state, is a little different. In Delaware, an individual has 300 days from the last date of harm within which to file a claim. It's called a charge of discrimination with the agency. That applies whether you go to the Department of Labor, the Delaware Department of Labor, or to the EOC. Okay, you have 300 days. So if you lose your job today and you're convinced it's because of your disability, you have 300 days from today to go in to file your charge. Now, each agency is a little different. The local agency, typically what they'll do is they'll set, depending on how close you are to that 300-day window, say you lose your job today and you go in to talk to them next week, well, they're going to set an appointment for you to come back with your documentation, meet with an investigator or an intake specialist, someone who can go through your scenario and determine whether or not, it's going to fit. Is it race? Is it gender? Is it disability? What are the facts? What are the details? And once that individual does that initial intake, they'll determine, okay, this is a case where we want to take a charge. And you will be given an appointment to go back and actually sit down with the investigator and put a charge document together. Mm-hmm. One thing that it's kind of a two-way street with these agencies because they cannot turn you down. They cannot say to you, oh, we're not going to take a charge. We don't think you have anything. Now, 30 years ago, when I was working in that particular office here in Delaware, we did have the discretion to tell someone who walked in, look, we just don't see that you have a situation that is within our jurisdiction. So we're not going to take a charge from you. 20 some years ago, there was a court case filed in Delaware where the DOL had refused to take a charge, and the individual then, because of the timeframes then were a lot shorter, they essentially lost their ability to file a charge of discrimination. So a very smart, enterprising plaintiff's attorney sued the Department of Labor, alleging that they had exceeded their jurisdiction and their authority by refusing to take a charge. So at the end of the day, if you say, look, I want to file a charge, they will take it. They don't have a choice. They have to take the charge. Now, they can take it. A lot of times people do come to these agencies and they think they have, some sort of a claim, and they really don't. Either they're way out of time or they just don't have a scenario that fits what the law protects. In that situation, the agency does have when they're doing an investigation, they do have the authority to say, hey, we don't see it. We're going to dismiss this charge, we're not going to continue to investigate it. But what they have to do at that point is issue what's called a right to sue notice. And this is a very, very critical document because it is the individual's ticket to file a lawsuit. With any violation of discrimination law, age, race, gender, what have you, you cannot simply walk into a court and file a complaint for employment discrimination. You are required by law to go through the administrative agencies. And the reason for this is if everyone who was going to these agencies went into court to file their claim, the courts would be flooded with these claims. The whole idea for the administrative agency is to provide a buffer to address and resolve these claims well before they ever see the inside of a courtroom. Now, you go in and file your charge. What happens next? A copy of that charge is sent to the employer. The employer is usually given two options. They can opt for mediation or they can opt for an investigation. Now, as a management side attorney, I always recommend to my clients that we're going to opt for mediation. We want to see what it is the individual wants. And I have had circumstances where we've gone to mediation. It's conducted through the agency with trained mediators. And an individual has said, well, if they pay me X, I'll go away. Well, X might be less than what you're paying for your, fancy lawyer to put on a suit and show up.
Right.
I literally had a case many, many years ago that we settled for $250. And I still had trouble getting now it was a case that if it had gone any further, the employee would have lost. They did not have a legitimate claim here. But I had to explain to my client, do you have any idea what you're going to pay me to prove that they don't have a claim? Mm-hmm. They'll take $250, write the check, make this go away. But the mediation process, that will filter out a certain percentage of claims. If the mediation fails, it kicks right over to the investigation track. The case will be assigned to an investigator. He or she will they have a lot of different things they can do. They can request records. They can speak to witnesses. They can conduct depositions if need be. There's a whole litany of things that the investigator can do. Eventually, they will reach a decision and they will either find cause, which is cause to believe that discrimination occurred, or no cause. If they find cause, they will hold what's called a conciliation, where they bring the employer and the employee in. And they say it's kind of like, I call it mediation on steroids, because they bring the employer in and say, look, we found that you appear to have violated the law. Now, what are you going to do for this employee to make them whole? And even then, the employer can say, well, respectfully, Department of Labor, I don't think you know what the hell you're doing. I disagree, and I'm not going to do anything. Well, then the ball, the employee gets the right to sue notice. Mm-hmm. From the day the employee receives the right to sue notice, they have 90 days, that's 90 calendar days, within which to file in state or federal court. If you miss that 90-day window, you've lost your ability to pursue relief for your claim. So hopefully by the time someone gets to that stage, they will have consulted with a plaintiff side attorney who can be assisting them in how to go to court. Yes, you can do it on your own. The courts have standard forms you can fill out for different types of claims. But if you're doing that, you are going to be facing down someone like me on the other side who does this all day, every day, and knows the system. And you're probably going to stand a pretty good chance of having your case dismissed. Because we know the law and we know the procedure, and you don't. And that maybe is a terrible way of saying it, but if you're going to, if you're going to get into a gunfight, you don't bring a baseball bat. You bring your own hired gun to that gunfight. And quite frankly, regardless of the jurisdiction you're in, there are some really good plaintiffs' lawyers who do a very, very effective job for their client. And you can bring an attorney into the process at any point. You can contact them first. There are some that will work with you to go through the Department of Labor process, and be with you every step of the way. If you don't need that, maybe you go just to get some perspective, do an initial consultation and say, all right, I'm going to try the Department of Labor process on my own and see how that works. But if that doesn't work, I'd like to be able to come back to you. And what I usually told people when I was doing plaintiff's work is, look, go handle that. Do that yourself. If the employer opts for mediation and you would like to have counsel with you during the mediation to advise you on what's a good deal, what's a bad deal, you can hire me to do that. Some lawyers will handle these cases on a contingent fee basis, depending on the circumstance. And you can bring the lawyer in at any step of the process and have them assist you. So those are, and ultimately, if things do not get resolved, you wind up going to trial. And very, very few of these kind of cases ever see the inside of a courtroom. They get resolved at the agency level, either through mediation or conciliation, or, the case gets a no cause finding and the employee gives up. There's a whole host of ways that these cases can go. But very, very few of them actually see the inside of a courtroom. And that's really the way it should be. A lot of these cases can get resolved early on and should.
This has been great. I'm so sorry about the technical difficulties, but I'm really glad that we had this dialogue. It's much better than the webinar. And so for folks that are watching, Kevin gave us a PowerPoint presentation. So we're going to put this video and the PowerPoint on our website, and we'll send that out to our members. But you have been so helpful, and the questions that people ask are really real, and they're things that make us stay up at night thinking about, so a lot of good information.
It it really, I have a child who has some let's say medical conditions that make work environment difficult. And I've lived through this as a parent, and not exactly the situation here, but I've had plenty of friends, family members who have experienced these kind of problems, and it is difficult. And as a management side attorney, you always want to tell the client, look, do the thing that is going to cause the least amount of risk. And frankly, if you just adhere to the law, in your interactions with your employees, and you comply with the law, well, theoretically, you shouldn't have to worry about a lawsuit. Mm-hmm. Not everyone is smart enough to do that, unfortunately. So, but it's been my pleasure, Beth. I really enjoyed it. Thank you.
Thank you so much for your time. And we just want to again tell our sponsors thank you very much for sponsoring. It'd be Biogen, Santen, and Spark Therapeutics. And Kevin, thank you for your time. It's a second go
Absolutely.
around. We really appreciate it. Thank you very much.
Absolutely.
I'm going to stop the recording. Thanks for joining us, everybody, and we'll see you again soon.